Yep. And then it goes on and it says, and we're reading right here. It is not clear from the opinion in Flake whether the court treats the right of publicity as a property or privacy based right. It says the court explicitly did not reach the question of whether First Amendment or newsworthiness defense might apply to such cause of action in other contexts. And then it goes on and it talks about this other case in Barr versus Southern Bell Telephone Company from 1972. The telephone company published a phone directory including an advertisement for the plaintiff's rug cleaning company. However, although the telephone company included the plaintiff's name, it used the likeness of an unrelated third party in connection with the plaintiff's name. So, in other words, they confused the picture with plaintiff's name. It says the plaintiff had signed an agreement that allowed for the commercial use of his image. However, the appellate court held that the publication of plaintiff's name in connection with the mistaken image exceeded the scope of this consent and might justify a finding of invasion of privacy. The decision implies that consent is a defense, but that if a publication exceeds the scope of consent, that the publication may be actionable. Now, I thought that was important to read also, Rodney, just because from the first video, I kept on stating that I believe implied consent exists. In some level of implied consent exists on the behalf of Jessica. You know, example, she called in demanding to receive Kevin's advice on a disagreement show. When Kevin agreed to give her the advice, Kevin said he's going to use this as a teaching lesson. Jessica said, okay. She never even asked what a reasonable and prudent person would ask is, what is a teaching lesson? She didn't say any of that. Kevin automatically, he popped her image up. Her camera feed was running so we could see the video of her. She already had her camera on. Kevin never asked her, to turn your camera on so I can see you. None of that. She already had her camera on. So obviously she wanted to be seen. Then she was dressed to impress. She looked her best, etc. She wanted to be seen. To me, that is all consent. That is all implied consent, right? So possibly Kevin might have a defense of consent, specifically implied consent. Possibly.
Right. So let me read that, Johnny. It says, so this right here is talking about this Bob Bell. This pretty much saying that there was a mistake in the image.
Right.
That was so the person whose image it really belonged to sued, not the person that gave consent with the name and image. But the fact that that image was not the image that the person gave consent to use is it saying that the owner of the mistaken image was the one that sued?
No. It's the plaintiff is the one that signed the agreement for his image and name to be used in the publication. But they publish his name, but they publish someone else's image with his name like that.
That's what I'm saying. So who sued? The third party?
No. The guy that had the agreement for his image.
Which guy? The one that gave consent to the image, or the one that paid for the consent?
The one that gave consent to the image. It's just they used the wrong image. Yeah, see, they just used the wrong image.
Who provided that? That's probably too much. Who provided the wrong image? The person that's suing?
No, the defendant. It's like they had a mix-up. It's what I'm getting from it. Yeah.
Okay, so telephone company. Also, it was a mistake.
Yeah.
So the plaintiff was okay. Go ahead. Okay, I ain't gonna get too much in this one. So in other words, I just want to understand that the bar was the plaintiff who provided his name and image. So that's like Miss Jessica.
Yeah, that's like Jessica.
Her name and image to the telephone company, which would be Kevin Samuels, the YouTube.
Correct.
You know what I'm saying? So if if Miss Jessica provided the name and likeness, we see that the plaintiff signed an agreement that allowed it. Where did Miss Jessica allow that consent with Mr. Kevin?
No, I see. I knew you was gonna point that. I agree with you. That the plaintiff in this case had a explicit, or should I say, an express agreement with the defendant. Now, what I'm saying is,
who made the mistake? The first person, the
defendant. The defendant made a mistake.
The defendant put the wrong image, not the image that Bar gave him.
Correct. So what I'm saying is that implied consent from Jessica's actions, right, exists. You know what I mean? I'm trying to prove that it exists. So I'm trying to prove that because the article says consent. It doesn't say that it has to be express consent. You see what I'm saying? Meaning in writing, y'all. For those who don't know what express mean, it means in writing. I'm saying that there's some level of implied consent there, and that could, and obviously the decision implies that consent, which in Kevin's case would be implied consent, can be a defense to actually help him to overcome the suit against him by Jessica. That's what I'm trying to explain. Do you see what I'm getting at, Rodney?
Yeah. That'll help him with that. If she talked about invasion of privacy.
Right.
Yeah.
All right.
There you go. That's right.
You gotta prove damages out, but let's get to the fun part. See, this is what people who watch Law and Order or Judge Judy and all these things tend to forget. They tend to forget this because they can hype each other up and tell each other stuff. If you've ever been to court, you understand that the people who tell the best story tend to lose in court because there's something called a countersuit.
That's right.
Frivolous.
Now, I'm going to stop right there because, yes, there is such thing as a countersuit. But again, in order for your countersuit to win on the merits, you have to state a legitimate, right, cause of action also. And you have to prove that you were injured in whatever that cause of action is. You got to prove your injury. So the same burden of proof that applies for the plaintiff, right, which would be Jessica, also would apply for Kevin Samuels, because once he filed a countersuit, he's taking a position as a plaintiff. So he has a burden of proof to prove his cause of action or his claims and allegations to be true also. So I wanted to make that clear.
Frivolous lawsuit, malicious prosecution. Yep. When you can show a pattern of behavior that where you actually were damaged by this person pursuing something frivolous, you can get treble damages plus attorney's fees. Like running around people calling straight men gay.
Right.
Now, I do agree with Kevin on that. You know what I mean? Because again, in that video that we watched, with our first video concerning this case, this lawsuit that Jessica filed against Kevin Samuels, we played a video that was done by TKO, or by Tanya TKO, and there are content creators, right, that are making allegations or allegedly slandering Kevin for being gay. That's why he's saying that. Now, again, I don't know whether he's gay or not. He's saying that obviously they don't know, but yet still they're making these claims. So that would be slander. If they don't have proof that the man is gay, that is slander. Anything you want to plug on that, Rodney?
Yeah, but as you said, but it goes back to what you said. He would have to prove how he was injured as a result of them calling him gay. And if they could prove that he is gay, then he wouldn't have a case. So he got to prove injury. Then they're gonna have to have proof that what they said was true. Go ahead.
Yeah, that's true.
And by the way, for the class, when he says treble damages, this means 3 times the amount that you asked for. So when the USFL sued the NFL back in 1982, the USFL won, but they were only awarded $3 because
Yes, Donovan Sharp is correct that treble damages is 3 times damages.
They awarded the USFL $1, gave him $3, and then of course the USFL went bankrupt. So treble damages means 3 times.
Right. So even if let's say you win what? What's the settlement? You win. You get awarded $10. But
all right,
then you can get countersued.
That's right.
See, this is where it starts to get trickery. You running around calling somebody gay, this or that, blah blah blah. Now there's some things I'm not going to talk about, but this is where actual law gets broken.
There you go. And I'm
gonna stop right there, because Kevin is implying that actual law is broken for slander. This is, in other words, what he's saying. But keep in mind that actual law is still broken for violation of someone's privacy. So just as much merit as what he's saying that his countersuit would have with these women stating that he's homosexual, right? Or shall I say Jessica, aka Miss Average at best, has just as much merit in her claims and allegations that possibly Kevin violated her privacy. Now again, we showed it. We showed, right, case law. We showed case law. Again, the case is Miller versus Brooks. It's from 1996. This case was issued in the North Carolina Court of Appeals. And this is where the court talks about appropriation of a plaintiff's name and likeness for a defendant's advantage. So again, just as much as these women may have violated the law by slandering Kevin, right? He also possibly had violated the law by misappropriating these women's name and likeness for his advantage. That's the point I wanted to raise.
Right. So if that's the case, his lawsuit will be moot.
Right.
Counterclaim will be moot.
Right. Yep. So, I mean, from what we can see, Jessica does have what she's saying. What they're saying that she's suing Kevin for is merit to it. Is the point? There is merit that her privacy may have been violated, especially if she can prove that YouTube is a commercial enterprise. And again, like we agreed to right now, I don't see where it's so difficult, because YouTube generates revenue. Content creators do generate revenue on YouTube. So it's not like something like like Facebook or MySpace, where people have profiles and people can view their profiles if it's set to public, but they don't receive any type of revenue for all the views that they receive of people viewing their profile. YouTube is a little different. Us content creators, we create content, people view it, and you get a certain amount of views, you receive compensation or revenue. So to me, that is a commercial enterprise, but we'll see how this play out. And again, right. And again, anyone that's listening to our videos, please, if you have access or if you have a copy of this lawsuit, again, please email us a copy to it. Our email will be in the description box of this video. Please send it to us ASAP. We would love to discuss the actual lawsuit. It would be awesome to see what was put in. It would be awesome for us to cover that, even to cover Kevin's response to her lawsuit. It would be fun. And as you can see, we bring the fire here at the Power of Offense. You know what I mean? We deal with facts. We have case law for your definitions. We do it all. So we entertain you with facts, right? Legal commentary from a layman's point of view, because we're laymen's, right? We laymen's that study and read the law.